There's been a lot of buzz lately about Justice Jackson's fiery dissent in Trump v. CASA as the Supreme Court wrapped up its latest term. But most of the criticism you hear misses the real point. Many Americans simply don't understand how judges judge. Today, we're diving deeper into the critical divide between formalistic judges, those who stick closely to rules and procedures, and judges who take a more flexible approach. This distinction isn't just theoretical. It deeply shapes how our country works. While the headlines might suggest this case was all about executive orders restricting birthright citizenship, the court didn't even reach that issue. Instead, the decision turned on a highly controversial judicial tool, the nationwide injunction, which we've discussed in earlier episodes. Justice Barrett delivered a compelling majority opinion rejecting nationwide injunctions, arguing they exceed federal judicial authority. Barrett's opinion surprised many observers who had recently criticized her for siding with liberal justices in other cases. But this really reminded everyone that judges are like umpires, calling balls and strikes, guided by the rules rather than politics or personal agendas. As Hamilton put it in Federalist No. 78, the judiciary has neither force nor will, but merely judgment. It is, in his words, the least dangerous branch, designed to interpret, not to impose. Montesquieu, who Hamilton quoted approvingly, put it even more bluntly. Of the three powers, the judiciary is next to nothing. What does it mean for a judge to be formalistic or results-driven? In everyday terms, it's the difference between a judge who strictly follows legal rules and principles versus one who bends or interprets the rules to achieve a perceived fair outcome in each case. In Trump v. CASA, we saw this contrast play out in real time. The majority used a formal, rule-focused analysis, while Justice Ketanji Brown Jackson, in dissent, advocated a more flexible, outcome-oriented approach. We'll explore what these trends reveal about how judges judge. Along the way, we'll compare Justice Jackson's flexible style to Justice Sandra Day O'Connor's famous case-by-case pragmatism, and then discuss three principled reasons why an informal, results-driven judicial philosophy can be problematic. In judicial philosophy, formalism, often associated with originalism and textualism, means sticking closely to the law's text, history, and established rules, even if that leads to outcomes one might not personally prefer. A formalist judge tries to apply the law as it is written, believing that consistency and fidelity to rules protect the rule of law. Justice Scalia, a well-known originalist, put it bluntly: if you're going to be a good and faithful judge, you have to resign yourself to the fact that you're not always going to like the conclusions you reach. If you like them all the time, you're probably doing something wrong. By contrast, a results-driven or flexible approach, sometimes called a pragmatic or case-by-case approach, gives judges more leeway to shape outcomes. Judges taking this approach might focus on the real-world consequences of a decision and aim to reach what they see as the most just or practical result for each particular case. This often involves balancing tests and nuanced, fact-specific rulings rather than rigid rules. Justice Sandra Day O'Connor was famous for this style. She often eschewed broad, sweeping rules in favor of narrow decisions that turned on the specific facts. Indeed, she became the court's crucial swing vote for years, precisely because of her case-by-case approach to jurisprudence. Such flexibility can make the law feel more adaptable and tailored to fairness in each situation. However, it can also make the law far less predictable and raise concerns about judicial overreach. Let's dive into this recent case, which nicely illustrates these contrasting judicial philosophies. Trump v. CASA was recently decided about the power of federal courts to issue universal injunctions. In plain terms, nationwide court orders that block a government policy, not just for the plaintiffs in a case, but for everyone. The context was an executive order by President Trump, which attempted to redefine who qualifies for U.S. citizenship by birth. Multiple trial judges had issued nationwide injunctions stopping this order's enforcement across the country. The legal question before the Supreme Court wasn't the validity of the executive order itself, but a rather technical one. Can a single district judge forbid the government from enforcing a policy against anyone at all, even people who were never parties in that judge's courtroom? The majority, in a 6-3 decision authored by Justice Barrett, took a formalistic line. They focused on the Judiciary Act of 1789 and traditional limits on judicial power. The court held that universal injunctions likely exceed the equitable authority Congress has given to federal courts. In other words, under the long-standing rules, judges can grant complete relief to those people who sue, but not universal relief to those who are strangers to the case. The Supreme Court accordingly scaled back the injunctions, allowing the executive order to be enforced against everyone except the specific plaintiffs who brought the suits. Notably, the court did not decide whether the executive order itself was constitutional. It was punted for another day. This approach was tightly focused on separation of powers and limits of judicial authority. Essentially, courts shouldn't leap beyond their proper role, even if a broader injunction might seem to be more effective. Justice Barrett's opinion took some direct shots at Justice Jackson's dissent, which proposed a very different vision. Barrett noted that the principal dissent by Justice Sotomayor, joined by Kagan and Jackson, at least engaged with the traditional legal factors. But Justice Jackson, however, chooses a starting line of attack that is tethered neither to the Judiciary Act nor, frankly, to any doctrine whatsoever. Barrett was describing Jackson's solo dissent, in which Justice Jackson argued that courts must have power to fully stop unlawful executive actions in order to uphold the rule of law. In Jackson's view, the fundamental role of courts is to order everyone, including the executive, to follow the law, full stop. She warned that if courts lack authority to require the executive to obey the law universally, it would leave a gash in the basic tenets of our founding charter. In plainer terms, Justice Jackson was concerned that limiting injunctions to only the plaintiffs in a case would let the government continue enforcing potentially illegal policies against everyone else, which she saw as an unacceptable gap in the rule of law. This is a classic results-driven argument. Jackson prioritized a practical outcome, stopping an unlawful policy everywhere, over a formal limit on judicial power. She essentially favored an expansive, modern view of the judicial role as guardians who can issue broad remedies for the benefit of all who are protected by the Constitution, not merely doling out relief to injured private parties. The majority sharply disagreed. Barrett responded that Jackson's vision would make even the most ardent defender of judicial supremacy blush. In a zinger of a line, Barrett wrote, "Justice Jackson decries an imperial executive while embracing an imperial judiciary." According to the majority, Jackson's approach ignored over 2 centuries of precedent and the Constitution's careful design of separated powers. This imperial judiciary line is rather important because, as we'll discuss, federal judges are not democratically accountable to the people, to you. So empowering them to use feelings and by-the-seats-of-your-pants standards to decide cases is a pretty bad idea. In sum, Trump v. CASA showcased a stark divide. The court's majority took a formal, originalist-friendly approach, stick to the traditional scope of judicial authority as rooted in historical practice and the Judiciary Act, and resist the urge to maximize the court's power just to achieve a certain policy result. They effectively said the rule of law sometimes means courts cannot do everything, even if the executive might be violating the law in some cases. Justice Jackson's dissent took a flexible, results-oriented approach, argued that in order for courts to truly uphold the law, they must have broad power to enjoin unlawful government action universally, focusing on the principle that no one should suffer from illegal policies, rather than on old jurisdictional rules. Up to now, we've seen the appeal of results-driven approach. It aims for fairness, considers real-world outcomes. But from an originalist or rule of law perspective, there are serious downsides to judges routinely taking a flexible approach. Let's discuss 3 principled reasons why too much informality or outcome-oriented judging is considered bad in our system. But before we do, let's jump back to Justice O'Connor once more. Justice O'Connor was famous for her case-by-case, pragmatic approach to judging matters before her. One example was O'Connor v. Ortega from 1987, dealing with public employer searches under the Fourth Amendment. There, she penned an operational realities test to decide the issue. But it wasn't a firm test, and it made it hard for government offices, schools, or police departments to design consistent privacy policies. O'Connor's vague and pragmatic test led to another 11 years of litigation on that issue without a clear result. Justice Scalia noted that the test was so devoid of content that it produces rather than eliminates uncertainty, because there was no meaningful explanation of what satisfies those operational realities. For a judge, that's problematic because these kinds of tests exacerbate unpredictability, arbitrariness, and confusion, rather than providing clarity to the public. So the first reason why informality is bad is judges are not democratically accountable. They shouldn't act like super legislators. Federal judges, and Supreme Court justices in particular, hold lifetime appointments. They aren't voted in or out based on whether people like their decisions. This insulation is by design. As Alexander Hamilton wrote in Federalist number 78, courts need independence to uphold the Constitution against momentary popular passions. However, this very independence means judges must exercise restraint. If they start deciding cases based on personal values or desired social outcome, I know the right result when I see it mindset, they're essentially making policy choices. But policy is supposed to be made by the people's elected representatives, not by unelected judges. In other words, judges should stick to what the law says because they have no mandate to impose what they think the law should achieve. When judges take more flexible or results-driven approaches, it blurs the line between judging and legislating, undermining the very anti-democratic design that protects judicial impartiality. We tolerate judges being unelected only so long as they faithfully apply pre-existing law. Once they appear to be creating new rules to get certain results, their legitimacy erodes. Second reason we have issues here, a case-by-case flexible approach undermines consistency and predictability in the law. The rule of law requires that similar cases be treated similarly and that citizens can have some predictable rules to guide their conduct. If every case is just an ad hoc determination of what seems fair or desirable to a particular judge, the law can become a jumble of one-off decisions with no clear principle. Justice Scalia and Justice Thomas frequently criticize multi-factor balancing tests and vague standards for this reason. They give judges too much discretion, leading to unpredictable results and potential bias. One of my favorite justices, Justice Black, was famous for noting the framers of the Constitution already balanced rights against potential infringements. Justice Thomas has explained that judges should adopt methods that constrain discretion. When interpreting the Constitution and statutes, judges should seek the original understanding of the text. This approach works to reduce judicial discretion and maintain impartiality. The greater the room for judicial discretion, the greater the temptation to write one's personal opinions into the law. If one judge can weigh fairness one way and another judge another way, outcomes will hinge more on the judge's identity than on the law itself, a troubling scenario for a nation of laws. By contrast, sticking to formal rules like text or original meaning yields more uniformity. It shouldn't matter which judges you get. What should matter is what the law objectively requires. As an originalist might say, the law's meaning shouldn't change from case to case or court to court based on a judge's subjective sense of justice. A case-by-case approach can also confuse lower courts and citizens about what the law actually is, if the Supreme Court is unwilling to draw clear lines. Predictability is not just an abstract ideal, it affects real life, your life. For example, schools and governments need to know what they can or cannot do in advance, rather than waiting to see how a particular judge balances the scales after the fact. The third reason here, an outcome-driven judiciary threatens the principle of a fixed constitution and separation of powers. The United States chose to have a written constitution, which implies a stable, enduring meaning that doesn't morph with each judge's preferences. Justice Thomas put it memorably, "We, the people, adopted a written constitution precisely because it has a fixed meaning, a meaning that does not change. Otherwise, we would have adopted the British approach of an unwritten, evolving constitution." If judges take an informal approach, essentially updating or reinterpreting the Constitution in laws to fit current views of what is good, then they're treating our Constitution as if it were unwritten or infinitely malleable. That undermines the very idea of having a Constitution that binds both the people and the government. From an originalist perspective, allowing judges to reshape constitutional meaning or statutory meaning for the sake of results is dangerous. It usurps the role of the people, who can amend the Constitution through Article 5 or change laws through Congress. Why bother going through the democratic process if judges can achieve the same ends by rereading the law? This also ties back to separation of powers. Each branch has its job. Congress makes the law, the executive enforces it, and the judiciary interprets it. If the judiciary goes beyond interpretation into the realm of making or unmaking laws to reach certain outcomes, it upsets that balance. Even well-intentioned, results-driven decisions can set precedent that permits future judges to act more like politicians, adjusting law to suit policy goals. Over time, that can weaken public respect for the judiciary as a neutral arbiter. People may start to see the courts as just another political body, which is the opposite of what the framers wanted. In short, an originalist would argue that stability, democracy, and the integrity of the judicial role itself all favor a formalist approach over improvisation, case-by-case approaches. From an originalist perspective, while flexibility can be well-meaning, it's ultimately fraught with dangers. It concentrates too much power in an unelected judiciary, leads to uncertainty in the law, and erodes the foundation of a written constitution. As Justice Scalia cautioned, a judge who always finds a way to get the outcome he desires is likely a bad judge. And as we've discussed, the reason is simple. Judges are supposed to follow the law, not field their way to a preferred result. The rule of law can be a bit mind-numbingly technical at times, to quote Justice Jackson's criticism. But those technical limits are a feature, not a bug. They ensure that we, the people, through our Constitution and statutes, set the boundaries, not the individual whims of those in robes. Judges are there to call strikes and balls, not to get into policy and political outcome preferences. It's tempting to sort judges into favored or disfavored categories when they decide an issue you care the way you hope they might. If you scroll through X just 3 to 6 months ago, you'll see discussions about wanting to impeach Justice Barrett because she ruled in a way that was politically offensive for some. Today, she's a hero because she ruled in a way that tickled the political fancies of others. And lost in between all that political drama is the reality of how real judges really judge. I think back to the example of Justices Scalia and Ruth Bader Ginsburg, who had quite differing judicial philosophies, but they had actual philosophies and enjoyed one another's company, including family vacations together. Judging usually isn't about politics. It's about something more, something higher. One video isn't enough to cover all these nuances, so pay attention for future episodes examining this in depth. In the end, how judges judge matters greatly. A formalist judge aims to be a neutral umpire, calling balls and strikes by the strike zone as written. A results-driven judge might feel free to widen or narrow the strike zone for what they think is the good of the game. As enticing as the latter may sound when you agree with the outcomes, it's the former approach that better preserves the rule of law in the long run. Judges, insulated from electoral accountability, owe us fidelity to the law above all. As Justice Thomas eloquently noted, judges must have the courage to stand by the decisions that an honest adherence to the law requires, even when the winds of public opinion blow strong. In other words, judicial duty is to the law, not to desired results. That principle, rooted in the Constitution's design, is why better judges favor formalism over a flexible, case-by-case jurisprudence that feels good in the short term. I'm Benjamin Barr, and I appreciate you spending time with us today. My job as a constitutional litigator is to give you the tools to be able to solve today's constitutional puzzles. Please join us again next time. Be sure to like and subscribe, and thanks for tuning in.